After apprising with the above said introductory facts, the witness Kailas PW3 declined to subscribe to the prosecution version that his sister disclosed him that as the accused assaulted deceased, he ran towards the well and the accused did not save him. Further, though the witness contended and that his statement exhibit 18 under section 164 of CRPC was recorded by the court at Bhokardan, but in the cross-examination by the accused, the witness has contended that Raju, a police, gave a question and answer and asked him to give statement in the court as per it. In such circumstance, the evidence of witness and that his statement was recorded will not be helpful to the prosecution to support its case. Learned APP elicited in the cross examination of the witness Kailas PW3 that his statement was recorded by the police and he stated to the police that accused used to assault his wife and children. Here it is to be noted that it is not the contention of the witness that he has witnessed the said assault at the hands of accused. Moreover, in the cross-examination, he has stated that her sister or niece never disclosed him that accused ill-treats them. Further, neither informant Jyoti, sister of the witness, nor Preeti PW4, niece of the witness, have stated about such ill treatment. In such circumstance, their contention about alleged statement to the police is not sufficient to prove the fact. Preeti PW4 fared no better. She informed the court that informant Jyoti is her mother, accused is her father, deceased was her brother, and they all used to reside in the house at their field. But as regards to the allegation again, the accused, the witness denied that accused used to always assault her and her mother and brother. On contrary, in the cross-examination, she stated that her father was not alcohol addict and did not assault her and her mother and brother. Though Preeti PW4 affirmed that her statement was recorded under section 164 of CRPC by the court at Bhokardan, but declined to own the contents therein. In view of aforesaid nature of the testimony of informant and the witnesses who were examined to lend support to informant's testimony, the very foundation of the prosecution case gets dismantled. The fact that informant has disowned the entire prosecution case, that accused was alcohol addict and under influence of liquor, he used to ill-treat her and children, and getting fed up of it, her son Nilesh committed suicide, removes the very edifice of the prosecution case, as the other witnesses, namely Kailas PW3, Preeti PW4, also deterred. The prosecution case enters in the realm of no evidence as to the allegations against the accused. In such case, the evidence of investigation brought on record through the investigating officer Santosh PW6 in regard to drawing inquest Panchanama Exhibit 11 and Spot Panchanama Exhibit 12, recording of statement of witnesses as per their say and bear contention that the guilt of accused is transpired in the investigation is not sufficient to prove the charge against the accused. The upshot of aforesaid discussion is that the prosecution could not lead evidence on either the prelude to the occurrence or the cause, in the face of the reluctance of the informant and other witnesses to support the prosecution. It cannot be said that prosecution has succeeded in establishing guilt of accused for offense punishable under section 306, 320, 350 of LPC. Hence, I am persuaded to answer point numbers 1 to 3 in the negative. In view of the negative findings to point numbers 1 to 3, it cannot be said that prosecution succeeded in establishing the guilt of accused for offense punishable under section 306, 320, 350 of Indian Penal Code. Thus, point number 4 answered accordingly. For the foregoing reasons and findings on point number 1 to 3, the accused deserves to be acquitted. The accused has furnished bail bond with surety under section 437A of the Code of Criminal Procedure for his appearance before the higher court as and when such court issues notice in respect of any appeal or petition filed against this judgment. I therefore pass following order. First, accused is hereby acquitted under section 235 into bracket 1 of the Code of Criminal Procedure of the offense punishable under section 306, 320, 350 of Indian Penal Code. Second, the bail bond and surety bond given by accused for his appearance in this case stands cancelled. Third, the bail furnished by the accused in compliance of section 437A of the Code of Criminal Procedure shall remain in force for next 6 months for his appearance before the higher court as and when such court issues notice in respect of any appeal or petition filed against him.